This is, I think, a storyline that's worthy of a John Grisham novel. And so the legislation in Canada that drives all of this is the Proceeds of Crime, Money Laundering, Terrorist Financing Act. That legislation, I believe, was enacted in 2020, I believe. No, 2000, somewhere right around there. And right around that time, FATF came in and did an audit of Canada. And they basically said, hey, good job, Canada, you're doing okay, but you got one huge problem, the lawyers. Because in the Canadian system, as you know, lawyers move the money on these transactions, and lawyers were not reporting entities under that act. So the federal government said, hey, no problem, we'll just add the lawyers. That started a 15-year legal battle because the law societies immediately jumped up and said, nope, stop. You can't do that. You can't force lawyers to have to submit suspicious transaction reports because it's a fundamental breach of solicitor-client privilege.
Okay.
So they battled all the way up to the Supreme Court. And in 2015, the Supreme Court sided with the lawyers. But they left the door open. Essentially what the Supreme Court said was, listen, federal government, you can't bring lawyers into the regime the way you're proposing to do it, but there might be another way you could do it.